I mean, that's all I do anymore, is sit down and read these books and, you know.
Well, why do you read their stuff?
Why do I read them?
Yeah, because this is a common law land. Why do you care less what they write in the civil code?
Oh, God, here he is.
He's going to save your day, buddy.
It makes me feel better.
Well, what I'm saying is, when they file a complaint against you, why don't you file a claim against them?
They laugh at it.
No, they don't laugh at it, because the claim goes first. Because the last one who places the claim gets their claim heard first. They won't. Oh, they might laugh at you, but if you know the law, they won't laugh for too long.
I tried to ask you for an example of your claim, and you you chewed my ass.
What was that? What was the claim that you?
Well, I emailed you and I said, do you have any examples of these claims you're talking about? And you said you seem like a needy person.
Yeah, I'm not sure who I said that to, but somebody's trying to give my stuff to somebody named in North Carolina guy, and I think they're going to use it for bad purposes.
This is Jeff, the Right Way Building and Rigging from Florida.
Oh, okay. There's somebody, no, rock class people were trying to get me to do that, and I didn't want to send anything to those people, you know, because I think they're just a little over the top for me. You know, they try to talk to the Pentagon and saying that when this government collapses, they'll be ready to jump in and take over. And I'm like, oh no, I'm not getting involved with those people.
You told me that, and I haven't heard Rod go there yet, but I have only been listening a short period of time.
Yeah, he said he's already been. They were already setting up like 2 representatives in every state, and informing the Pentagon in Belgium. And like, oh no, I just want to deal with traffic tickets, maybe getting your kids back from the CPS people, maybe mortgages, and dealing with the IRS. I don't want to talk to no Pentagon people. I just want to deal with traffic tickets. So this man just wanted to do the traffic ticket. So that's all I was trying to tell him, is that you just have to say that you were making a claim that somebody was interfering with your rights to travel because you've caused no man harm. Since you caused no man harm, they are filing a false claim against you.
Correct.
So that's all you do. You just say, you know, I need to see the one good thing, I bash Gordon Hall a lot, but the one good thing he does say is that conditional acceptance thing. But I just make it a lot shorter. It just says, you know, he says, well, he says, I conditionally accept your offer upon bona fide proof of a claim. And I just stand right there and I say, don't say anything more. Just say, I conditionally accept your offer that I've done wrong upon a verifiable claim. So just...
Yeah, verified, and valid and verified.
Valid and verified, correct. Well, they just handed me a copy of some, you know, the tickets. Says, there you go.
And just say...
To sign it, you know, put a blue ink, you know, certify this. And he says, well, I don't have to. It's a public document.
No, you don't certify anything. It's a verifiable claim. See, certified just means that somebody else believes that that piece of paper exists. When you go down to a notary certifies the document, correct? Okay, yes. What happens is all you're asking the notary lady to do is say that this piece of paper existed on this day. She doesn't read the document. She couldn't care less what's on it. You can't bring her forth to the court to have her verified that anything on that document is true. Certified just means that there's another person that believes that piece of paper exists. Certified is a total joke and is a waste of time. What you need to do is have it verified. See, lawyers can only certify things. So if you read at the bottom of every lawsuit, it's like, I certify everything in here to be true, whatever. That's all nonsense. Yeah, or read everything that everybody cut copies and paste. Every Title 42, 1983 complaint, you'll see everything at the bottom is certified by you pro se plaintiff people. You don't certify anything. Lawyers certify things. What you do is verify it, and you demand that the other side also, the only answer that you'll accept in court is a verifiable answer. And the other side can't verify their answer. They can only certify their answers. So in this land, to give testimony in open court, it has to be verifiable. It can't be certified. It's got to be verifiable. There's got to be a man who's willing to put his hand on a Bible and swear to it. That's verified. That's the difference between verified and certified. Verified is viva voce. It's by your voice, by your mouth. If it doesn't come viva voce, just Google viva voce, and you'll see what I'm talking about. And
you know, I tried to pull that today. I asked the judge, because they switched the prosecutor on me, and they still haven't, the prosecutor still hasn't had a meeting with me. So I ended up, I said, maybe I can use this to have the, do a catch-22 and have the prosecutor swear in, and I think you've made that comment, the prosecutor won't do it. So I asked the judge, can you swear us both in? And he said, no, we're not going to do that.
Well, you told him, you said you need it for appellate review. Say, is it not true that for any evidence or facts to be presented to the court, it has to come through a verifiable witness? And he'll have to say, yes, that's true. So say, before we start, just in case I need it for appellate review, I need to be sworn in, so that way my testimony can be heard by the appeals. Because if you don't, the only testimony that the appellate court is going to hear is something that was verified under oath of affirmation. So if it's not verified under oath of affirmation, you have nothing to appeal.
Really?
Really? Yeah, it's just that simple. I mean, all you have to do is it's a federal. If you actually like to play with federal rules, it's a federal rule of civil procedure, Rule 602. It's just personal knowledge. So, like I said, the only thing you have to say anytime you ever step before any kind of court is just that you have to say to the judge, is it not true that for any statement to be deemed admissible evidence, it has to be under oath of affirmation? And the judge has to say yes. He has no other choice. To be admissible evidence, you have to. And then you say to the judge, therefore, before we proceed, you just say, it's my wish to be sworn in through affirmation. Therefore, there could be admissible evidence pressed upon the record in the event that it needs to go for an appellate review. And that's the appellate court only reviews things that were sworn in under oath of affirmation testimony. If there's no testimony for the appellate court to review, there's no case for them to hear. So you say, therefore, before we proceed, it's my wish to be sworn into affirmation, and then I wish the other side to do for the same. And in the event you need an appellate review, and Angela sees that on, she put that on her Irwin Schiff's site. That case that I'm referring to is that Transi versus Pagliaro, 1964, where it says that no attorney could present any facts or evidence or onto the record unless he has any first-hand knowledge, and that's that federal rule of evidence 602.
Well, it's the state of Florida against me in all capital letters. So I thought this should be an easy one to shake off. And it's well, trust me, it's not looking good so far because the judge is in on it too.
Because the only problem is that you didn't file a claim, did you, against them?
Actually, you know what I did? I just I've been playing in the private. This time I filed a motion for a show cause hearing, a declaratory judgment in the nature of a writ of error, quorum nobis, and a demand for dismissal for failure to state a proper jurisdiction and venue. He didn't. It was like I didn't do a thing. He just ignored it.
Well, the big thing is, like I said, you don't have a motion to court, a petition to court. That's begging the court. And once you motion to court, you're giving the court jurisdiction, because you can't order something to do something that doesn't exist. So you kind of look like you're an idiot to yourself. You know, like you're turning on yourself. It's like you're motioning the court. Motion to court for what? You notice the court that it lacks jurisdiction over you. You notice it. You give it notice. You don't motion the court that it has no jurisdiction. That sounds ridiculous. You're saying, okay, court, you exist, but I'm saying you don't exist and you don't have any control over me. Then why are you talking to the court then?
Guy, I thought you said originally you weren't talking in court. Now you are?
You give the court notice. Now, when you see you got a notice on a bulletin board, what do? You put it in writing and you wrote the word notice on it. I believe that there's no man will come forth and claim that they have jurisdiction and control over me, because all jurisdiction means is control over you. Who's got the power to touch you and drag you in? Who did you cause harm? Because, like I said, it's very simple. Everybody knows the 10th Amendment says that whatever power isn't reserved with the federal government, the power power is reserved then with the state and with the people. And power means to control over another person. So you have control over me when I'm stepping on your toes. If I'm stepping on your toes and you say, hey buddy, you're stepping on my toes, back off, and I don't, well then you have the power to control me, to control my actions. You have the power to push me off your feet. So you have jurisdiction and you have control and authority over me at that time because it's necessary for your self-preservation. So you have the jurisdiction. All jurisdiction means is you have the power to drag me into a court before a jury. Do you have that power? Do you have that authority? Of course you do. If I've caused you harm and you could prove that harm and you're willing to prove it and I won't settle the matter with you on a private side outside of the courtroom, you have to drag me in. So that way you get the marshals to drag me in or the sheriffs to drag me in to answer to your claim against me. So you have the authority over me, jurisdiction. That's all jurisdiction means. So you're challenging the judge. What man did I cause harm to that I was not willing to settle this matter on a private side that you believe, or somebody believes in this building, that you have the right to summons me here, drag me in, and then force me to do something? Who's got that power over me? So the judge would have to say, well, he does. It's like, okay, so you're claiming I've done you harm? He'd be like, well, no. Well, then you don't have jurisdiction over me. Who's got the right to claim that I caused him harm? Let that man come forward and speak his piece. I'll settle any matter that I caused any harm to anybody. That's all jurisdiction means. You guys must be getting extremely confused with the word jurisdiction means. It just means who's got the right to control of the power over your body.
Right. And when the supposedly going to your brother, the prosecutor, they've been avoiding me like the plague. So what do you do?
Prosecutor is not the person that you've caused harm to. You need, if you're saying that the prosecutor has to be prosecuting a claim. So you say to the prosecutor, whose claim are you prosecuting? Bring the person that I've caused harm. The prosecutor is more like the trustee. He's the one who's actually just performing a job for the person who made the claim, the trustor, the grantor.
Right.
So, is making who made the claim. The prosecutor didn't make the claim. He's the trustee. He's acting on that claim. He's the worker. He has an EE at the end, like an employee. He is the trustee. He's the one who's moving the claim. The claim for who? Please bring the grantor, the trustor forward. Let him in, because everybody knows in ancient English law, to this day, the plaintiff must appear. The person harmed has the prosecutor. The one who's claiming he's been harmed has to appear at the trial. The defendant doesn't have to appear. The defendant could have a default judgment against him, or the defendant could have a lawyer represent him. But the person who's actually making the claim must appear so that the defendant can cross-examine him on the witness stand in open court.
That's right.
So he must appear.
Doesn't that defendant's name have to be on the charging instrument?
Honestly, no, not really. I mean, look at, like, say something simple like that guy named Prince. That guy, he had that funny symbol on his name. You know what you have to do is point across the courtroom and say, that man right there, I don't know his name, but I swear it's that guy right there, and I got 50 other people who will point across the room and say, that guy did it. Do we know his name? Yeah. We need an eyewitness. Just like the OJ case, you need somebody to point across the room and point out OJ killed that lady in Brentwood, California, until somebody comes forward and says, I don't know his name. It's like old Julius Landers, whatever his real name is. I say, I don't know, but that's the guy. I saw that guy chop that lady's head off on that sidewalk that night. So do you need another name? Nah. That's not important. You just need to be able to point a finger and say, I see you do it.
Well, so in the event that this goes all the way to trial, then this deputy can appear and point the finger, and who knows, or who can dispel the fact that he's lying or not?
Dispel what? Did you cause him harm?
Yeah.
You hurt the deputy? What did you do to him?
I told him that when I was cuffed in the back of his car, I said, do you know how much this is going to cost? You could lose your house, and that's what that was my oops.
That didn't cause the man any harm. The man is going to have to bring forth a verifiable claim that by you uttering a statement has actually caused him a monetary loss. So did he bring his monetary loss before the court yet, the judge?
No, well, but it's putting me in a real pickle. But no, not yet. He just wrote up a felony charge.
That's right. But whoever creates the charge is burdened with that charge until you
He's
accept.
probably got it on audio also. He probably had a recording going.
Fine, I could charge you anything, but you have to accept the charge. Now, you don't have to accept the charge. You said I'll accept the charge upon a verifiable claim. Just because you get charged, like I said,
Right, make him prove it.
Right, he has to give you make a verifiable claim that he suffered some sort of monetary damage. He has to something tangible, not something intangible. Like, well, you caused me a lot of stress, and I hurt my feelings, and raised my blood pressure. You're gonna say, "Oh, dude, I want to see something tangible. You show me that I did something that caused you monetary damage. It defaced you in the community. You lost your status as a cop.
Yeah, the harm. Where's the harm?
Something tangible. Show me. Give me a bill."
I'm recording. Yeah, this is being recorded. So thanks, Karl.
All right. I mean, I think everything's pretty simple. You guys just the worst thing you folks do is like I said, Dean Clifford really liked what I said that to him. I said, your number one mistake, Dean, that you make a million times. And he's like, what's that? And I said, you keep relying upon their rules, their laws, their citations, their decisions, their opinions. I said, it's
no, he doesn't.
I said, what he does is he's got his overhead projector if you watch his videos. And he says, look at the Canadian rules, blah, 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 blah. Look at the Supreme Court of Canada decision, blah, 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 in 1802. I said, stop that. I said,
well, maybe that's just part of his teaching process, but he doesn't rely on them.
Oh, he was on a show with you and me, and he said, "Oh, lovely, Karl, lovely." He's like, I see exactly what I'm doing wrong. He says, "You're absolutely right." It's on one of your shows. It's like call number 199.
Oh, cool.
81. He says that I said to him, "Look, what you need to do, Dean, is to stylize it in your beliefs. To say, I have the right to travel across Canada and be left alone. Nobody has that right to interfere with me unless I'm causing them harm. Then they have the right to control me and stop me from causing them harm. I totally believe in that. Not only is that my belief, but the Canadian Constitution of 1802 clearly says this, and the Supreme Court ruling of Canada of 1965 clearly says this. That's how you stylize it, because that's how you put your beliefs in conjunction with their beliefs. And then I go, he says, I see exactly where you're going with this. I said, exactly. Because if you want to rely on their beliefs, how do you know the Supreme Court didn't make a decision in 2011 that totally contradicts what you said that they said in 1965? So stop caring about their ordinances and their codes and their opinions, because their opinions, codes, and ordinances can change. But your beliefs always stay the same. As long as I don't hurt nobody, who the hell cares what I do? I said, just convince the jury of that now, Dean. I said, that's the whole trick. So he's like, I see that. Lovely, lovely. If you go back to listen to your show, and she's cursing at everybody but me. And then he was talking. He says, oh, that's lovely. That's lovely. He says, I see exactly where you're going with this. He said, oh, boy. I said, yeah, Dean, I said, it'll work. I'm telling you, man. I said, you just have, it's your beliefs. Because if you rely on the judge's opinions or somebody else's beliefs, it's not your beliefs. And if you're a man, you believe that you can do whatever you want, right? He said, absolutely. I said, okay, well then, man, stop relying upon somebody else's beliefs.
He's in the pokey there right now, though.
Oh yeah, I just read that on the internet. I think somebody said that. Like I said to him, I said, you got a good thing going there, kid. I said, you seem a little angry, but if you could calm down a little bit, I think you're going to go far. I said, you take this stuff a little too serious.
I got a question for you. Now, if this gentleman goes to trial, like I was getting ready to do, and he'll get a copy of the jury instructions. Now, how do you overcome the jury instructions?
Well, you're going to go in a trial to answer to somebody else's complaint?
Well, I mean, if he goes to trial, yeah, I guess so.
Okay, this is the I try to tell everybody all the time, a million times. You never let them drag you. You never just go in there one-sided. Who's the man with the long beard? He always says that to you. As a defendant, you can never win. The best you can do is break even or a draw or lose. So you have to always come in as a prosecutor. You have to prosecute a claim the same time somebody's making a complaint. And a claim always trumps a complaint. So you have to come and you have to file a claim. You have to say that they administrating my property without any rights. I claim that he told me what to do with my car, and he had no right to tell me what to do with my car. And then he has to prove he had a right. The only problem is for public officers and state employees, they have no rights. Only man has rights. So they have duties and responsibilities and obligations that they have to uphold. So right off the bat, there's no doubt about it. It's like, does that policeman, do you have any rights? It's like, well, what? Do you have any rights to stop my car? No, that's a duty and obligation or some sort of authority. But in this country, rights supersede and trump everything. So do you have a right? Well, no, not in the capacity as a policeman. I have a duty. That's right. But me, as a man, I have a right. So, did I have the right to travel to my car? Yes. Okay, in the pyramid structure of this society, what's on the top of the pyramid? Rights. What's under pyramids? Under rights? Duties, obligations, responsibilities, and privileges. Can somebody take away your privilege to be a cop? Yes. Can you no longer then stop people driving down the road? Well, then, right, I couldn't stop them. Why? Because it would be unlawful. Why? Because you didn't interfere with that man's rights, right? Yeah. So as a cop, you have a privilege to stop me, right? Yes. Okay. As a man, do I have the right to travel from point A to point B? Yes. Okay. So you had a duty, right? Yeah, well, I have a right. So what trumps what in this country? Privileges, or duties, or rights? I had a right, and you interfere with that right.
Okay, but do you use the Constitution?
No, you could refer back to the Constitution. You could say, I believe I have the right to travel, and not only do I believe that I have that right, the Ninth Amendment also secures and protects that right. You never rely upon somebody else's document. You can refer to it.
Okay, so wait a minute, Karl. So you're talking to a cop, and you ask the cop this question, and the cop comes back with, oh, are you one of them sovereign citizens? Then what do you say?
Well, when a cop gives me a ticket, I love taking tickets, because to me that's...
No, it wasn't that. I asked you if the cop asked you, are you one of those sovereign citizens, what would you say?
I said, the only thing I know is I'm a man. That's all I know, is I'm a man. I said sovereign, that I don't know. But what I do know is I'm a man.
Thank you.
And
That's what I want.
I don't get into theory with a policeman on the side of the highway. You know, when, like I said, you know, believe me, the way I look, believe me, I put my wallet on top of my truck, put my hands around the outside mirror, and tell them, handcuff me so we don't have any accidents. So being a big, goofy-looking biker guy my whole life, I know just to basically sit there and shut the hell up. Let him do his thing, and then I'll deal with it in paperwork. I'll handle it outside of the courthouse, because I just, you know, I give everybody an itchy trigger finger when they see me. So I'm smart enough to just, I'm a big, goofy-looking guy, so you know what? Don't give them a reason.
Yeah, really.
Women have a time because they guess they don't figure that a cop's going to put a bullet in their head, you know. But I just presume they're going to put a bullet in my head, so that's why I get along great with cops on traffic stops, and they just give me the tickets, and I bring it back down. I told you that story plenty of times. I said that you just bring it down within 72 hours, and you just say that this is some sort of a complaint. It's like, yeah. They said, well, I'll answer anybody's claim. Is anybody making a claim that I caused anybody wrong, that I caused a harm to anybody? Well, no. He's filing a complaint. I said, well, then I can't. This time I can't be bothered answering every time he makes a silly complaint against me. So at this time I'm going to have to return these subpoenas or summonses, citations. And they always laugh at me. So, well, we'll see you in court in 30 days. I said, okay. I said, the only problem is I gave you fair warning, and you're going to lose. And when I've proved that you filed a false claim against me, I'm going to hold you liable. So they're like, yeah, well, good luck with that. We've never lost. And I'm like, okay. And then, like I said, when you take him into court, then you just file a claim that you tried to settle the matter with him on a private side, and he refused to. And that he's filing a false claim against you, because no man is going to come forward and verify this claim that I caused him any harm. And when no man comes forward, it's like, there you go. What did I tell you? I told you no man was going to come forward. I said, and I always trick the judge and everybody when we first start this thing. They say, okay, everybody's here today. I said, yeah, I think we hear something about I broke the law. I think somebody said I broke the law. Did I break the law? Mr. Cop over there? Yeah. Okay, Mr. Prosecutor, did I break the law? Yeah. I said, is that what we hear about, Judge? He said, that I broke the law? He was like, yeah. I said, okay. So then when they start talking, I said, no. I said, what are you talking about? That's Section 60101. That's some sort of violation of a code. We all agreed that I was here today because we would discuss the fact that I broke the law. Oh, you don't know the difference between the law and the code? Here, let me show you in your own book. This is the difference between the code and the law. And they're like, oh. I said, yeah. So everybody agreed when we first started that we'd be here to discuss the fact that I broke the law. So you all lying now? Did I not break the law? And they're like, well, law is like any cause of harm to loss to man. Any man going to come forward and state a claim? No.
So Karl, you're saying, is any man going to come forward to state a claim, and a cop can't come forward as a man to state a claim because he's acting in his capacity as a cop? Is that your catch-22?
Because only a man can make a claim in this country. The only thing that the state can do is make a complaint, file a complaint against you. They can't file claims against you. Why? Because you created the government. You created the office of the judge. You created the office of the sheriff. You created the office of the marshal. They can't make claims against the people. They can only file complaints against a person. Only man has the right to make a claim, and only man has rights in this country. God bless America.
Okay, so Karl, if I have an affidavit of obligation, and I put that in as my counterclaim, I turn the affidavit of obligation into a counterclaim.
The only problem is you don't have filing a counterclaim, because all they can do again is file a complaint. So you don't want to file a cross complaint or a counter complaint. You want to file a claim. So if you made a cross or if you made a counter, you'd be making a counter or cross complaint. If the state agency or government agency is bringing up something against your person, and if you filed a counter, you'd be down on their level. You'd be in the complaint land instead of being in our claim land.
All right, I'm gonna email you again. See if you can't find it in your heart to send me an example of what you're talking about, please.
All right, yeah, it's pretty simple, man. I think, like I said, if you guys start understanding these little simple word tricks, is this government always can make complaints. They file complaints against you. Man can make a complaint if he's dumb, or he can make a claim, and only man can make a claim because only man has the rights to make a claim. So
well,
sweet.
I just got it. I mean, it made sense this time. So thank you.
So if you listen to the Dean Clifford show with Ann back on episode 191, he says, I can see it. He says, I'm seeing it now. I see it, Karl. I see where you're going with this. Oh my God, that's lovely. It's beautiful. I see it now.
I have on the guest speakers page, if you click on Karl's name, Karl Lentz, it shows you episode 187 and episode 191 and the dates. There's partial transcript of the conversation there, and there's his email address, and what, about 15, 18 items that he sent me already. 1, 2, 3, 5, 7, 8, 9, 10, 11, 12, 13 items that you can look at. And
what I really like is when I hear people saying that to me, it's like, oh my God, I can finally see what you're saying. Now it's starting to make sense. It's all words, play on words. It's like, yeah, that's all they're doing is a play on words. Like poor Irwin Schiff, he didn't realize he was the prosecutor in the IRS complaint against him. Everybody thinks he's the defendant. He wasn't the defendant. And this is what, and like I said, they say, no, he was the defendant. No. Because the IRS said if he doesn't like the tax assessment against him, he can petition the court. So the person who petitions the court is the initial filer. The one who petitions the court is the plaintiff. So the IRS always gives you these silly things that says, if you don't like our tax assessment, please petition the tax court at your earliest convenience within 90 days, or we're going to start leaning things or what against you. So once you become the petitioner, you're the one who moves the court. So it's no longer that you're the defendant and they got to prove in this country. They have to prove, the burden of proof is on the prosecutor, not the defendant. So when you guys all try to say, well, I'm the defendant and you got to prove your case against me, no, not in tax court. Because you're the petitioner. You're the one who started the case into the court. that the IRS was working with you on a private side. And they tricked you. They're taking it out of the private side and filing it into a tax court.
Okay, well, what about a circuit court and a criminal charge?
That's the whole thing, too, with the criminal charge. If you personally injured a man, harmed a man, oh, yeah, then you're in trouble. But if it's something like silly like a drug kind of case, yeah, well, then, again, that's a violation of a code. And that's a complaint. There's a criminal complaint filed against you.
Okay, that's what?
Yeah, that's what we see. You say there's a criminal complaint against you, right? It's a complaint.
Well, it's a complaint and a charge, what's the difference?
Well, a charge is, like I said, when somebody wants to charge you with something, you just, wait a second. You want to charge me with that criminal complaint? Yeah, well, I can't accept that charge until I've been criminally indicted before a grand jury. And you're like, what? So I'm not bearing that burden of that charge. You hold on to that charge into your back pocket until the jury comes down with an indictment, and then the jury places that burden, that charge off on my shoulders. Until then, you hold that charge. I'm not accepting that charge at this time. Because you'll always see the judge say, come forward and sign this thing. And you're signing it, and you just said to the judge, like a $50,000 bail, $5,000 bail, sign this piece of paper. You're taking the burden of that charge on. So like I said, I remember this one lady, she just got stopped in a car, and she had one pill in a medicine bottle, but it had no white wrapper around the medicine jar. So the cop said that, hey, this is a prescription pill, this is a prescription drug bottle. If you had no paperwork on here, and they charged her with a felony for like having a non-prescription drug is like some sort of felony. And I said to the lady, I said, well, what did the grand jury have to say? And she said, what grand jury? I said, you can just accept the charges without demanding that you have the right to go before the grand jury to have the indictment passed down on you. She said, well, no, they just took me in court and they gave me like a $50 appearance ticket, or left me on my own cognizance, a $50 fine, and I said, to come back to deal with a felony charge. I said, baloney. I said, I wouldn't accept any charges until it comes down to the grand jury. I said, do you realize if everybody demanded that the grand jury comes down with the felony indictment against you, I said, do you realize how clogged up the court system would be? Nobody would be charged with a felony anymore. Everybody would be charged with misdemeanors. But if they were to charge you with a felony, you have the right to say, well, I can't accept that charge at this time. I want a grand jury to indict me. I'm not answering this felony until I'm indicted.
Now, a grand jury is going to be their hand-picked 12 people, right?
No, the grand jury is, well, supposed to be 25, but in most states it's 23. So when they're coming down with an indictment, a criminal complaint, you also present your claim to the grand jury. You file a claim with the grand jury at the same time. You say to the grand jury, oh, good, we're going to hear this criminal complaint against me? Good. At the same time, you're going to hear my claim against them, that they interfere with my right to travel, or they took my pill, or they took my bottle, and they have a right to take my bottle. I didn't give them any administrative capacity over my property. That pill was my property. That junk was my property. It was in my possession. It was under my control. They have no rights. I have rights. They have duties, privileges, and obligations. I have rights. See, it's just a play on words. That's all this stuff is all the time. Is that common law, man has rights, and our property can't be interfered with unless we give another man consent. And all the state governments can do is file complaints, and all they can do is they have a privilege to do something. So man always trumps. Man always trumps in this country. If we were in France, all the stuff I just gave you could be totally ignored by their courts. But we live in America, so we trump over every single thing that the government does. Everything. Taxes, tax code, everything. Like I said, I told everybody a million times, my mom was a federal agent she was a tax auditor from 1972 to the mid-90s. So she taught me everything. She said, you're the one who petitioned in tax court. The burden of proof now is on you. That the IRS doesn't have the capacity to tax you. You're not the defendant. You're the prosecutor. You petitioned the court. It's like watching the old movie, watching the old Bible movie, King David kind of thing. There's people petitioners outside of his castle waiting to have their case heard. They're the petitioners. So the IRS tells you, so if you want to challenge our assessment on you, file your petition with tax court or at this address within 30 days, or we're going to start doing some really bad things to you. So what you should have done is just keep sending letters back and forth to them and say, wait a second, you have the right to claim that I owe you a debt? Who has that right? I thought you were the IRS. I thought you were a state agency. I thought you had privileges, duties, and obligations. Where do you have a right? Do you have a right? Can you show me where you have that right to make a claim against my person or my property? And they don't. They have no right. No man's going to come forth. Like I said to my mom, it explained to me really simple. I said to my mom, if you assess a man $89,000, $1,217 in assessment, and you'll hand him across the desk and you hand him, he said, yes, I'll say this is what you owe. And I said, now if the man says put it in writing and sign it, now that you put it in writing, now sign it and testify that in open court. She said, I will never do that. She said, why? She said, we all know that's fraud. She said, but you could actually fill out the assessment form and throw it across the desk and tell the man you better pay it or else. He's going to have a really bad life. She said, absolutely. She said, I said, but now if the man said sign it, and will you testify to that in open court? She said, of course not. I can't testify to that. She said, I have no first-hand knowledge of any of that information on that paper. All I am is the tax auditor for the IRS. I know how much money this man really made. So I said, my mom said, it's all fraud. She explained to me in less than 5 minutes. I remember exactly where she was standing in 1987 when she told me. It took less than 5 minutes to explain it to me. I was like, it's all fraud. It's simple fraud. She said, then why do people pay it? She said, because they're afraid they're going to get in trouble if they don't. She said the same reason why I was paying my taxes up until doing that IRS nonsense, up until 1988. I did the same thing. Everybody else was doing because I was afraid. I was like, oh, okay. She said, are you afraid anymore? I said, no, now that you put it that way, no. She said, now what do you file from now on? I file every year I'm exempt. She said, there you go. Just make sure you file exempt every year.
File what?
You just file exempt. You just any kind of paperwork that anybody, the W-2 form, was it W-4 form they hand you?
Yeah. But I mean, you don't file a return and put exempt on there, do you?
I just file it on my W-4 whenever I start a job or something like that. Anybody tries to hand me something, I just file exempt on it.
Right.
Or you write NA. Now, what does NA mean? Everybody knows what that letter N with a slash and an A. They always tell you to write all the time, right?
Oh, yeah, not applicable?
No, not assumption. That means I am not contracting with you.
Oh.
See, everybody thinks means not applicable. See, I think lawyers taught somebody that just not let normal people like you and me know what NA really is.
I always thought it meant not applicable.
And that's what I thought for first 20 years, 30 years of my life. My mom explained it to me.
Or Narcotics Anonymous.
No, just N-O-N-S-S-U-M-S-I-T, not a subset. That just means that means I'm not going to contract with you. This is not binding. So she said to write N-A-N-A-N-A-N-A-N-A-N-A through all the boxes, and at the bottom one she said you highlight it, take a yellow highlighter, write exempt across it. She said you keep the original, you make a copy of it, and you hand it to your boss. And she said that way you keep the original in your files forever.
That's right. And only you can make that determination of
That's
your
right.
status.
Right. And nobody else can. So then no man will come to court. No man will come to court and testify otherwise. Because she said, my mom said, a federal agent will never come to court and swear under oath of affirmation to anything being true. They don't know. She's like, I don't know. So like I said, I got lucky that my mom was an IRS agent for so many years. And my sister just worked part-time there, just during the busy season. She just helped with the filing. But my mom actually was a tax auditor. So she actually ins and outs.
God, how does she live with herself?
She said, well, who do you think paid for that dining room table and the living room furniture? I said, Mom, come on, you work do something else. She said, well, it's all what they believe. So she said, so now, you believe that you owed this for all these years, right? Until I explained to you in 1987. I said, yes, Mom, I did. She said, now, don't you feel so much better now that you know it's true? I said, yeah, well, she said, well, eventually all these people are going to realize what is true. It's going to make them closer to understanding the difference between a man and a government. This is not the difference between you being a man and you being like an employee or a servant or a citizen.
In other words, your mom said, let's take advantage of the poor slobs until they wake up.
And then once they know who they truly are, once a man truly knows who he is and who the government is, let them be subjects and slaves to the government.
I can't justify it. I don't know. That's like being a cop and keeping your mouth shut. It's the same thing again.
Right, she's like,
you know, whatever.
Going back to NA, instead of writing UCC 1-308 and all rights reserved, you can just put NA?
yeah, just NA, because that UCC 3018, everybody knows that those codes change, just like the federal codes of civil procedure changes every 6 years. And the last time it was changed was 2007. So now it's going to be changed in 2013. So their codes change and modify at will, you know, like usually within every 6-7 years. So the next thing you know, remember it used to be UCC
207.
It used to be 207, right?
I think so.
And now it's 308.
Got it.
That's what I'm saying. It changes. So everybody used to write 207 on it. Now it's 308. Next year it could be 409. Who knows? So like I said, instead of playing silly games of what they believe is true, you say, you know what? It's not. It's not. I'm not a substance. I'm not contracting with you. No, thank you, but no, thank you.
I don't know if I spelled it right. Is that right? Non-assumpset? See what I typed?
You just let somebody Google it. I'm saying it'll pop right up.
Spell it again.
It's just like ASS.
Yeah.
And it should be UM, like SI, like sit, sit. You know, it's basically pretty simple like that.
ASSUM.
SIT.
Oh, I put a P in there.
Oh, yeah. I think most people think.
ASS.
Yeah, I don't think it's.
MSIT.
Yeah, I'm not on a computer, so I'm not sure. I'm pretty sure.
Okay.
Yeah, I'll walk to the computer and take a look, but I'm pretty sure there's no P in Assumpsit. I think people pronounce it like that. It might be the P in it. I'm not sure. Did anybody Google it yet?
I don't see it yet.
Yeah.
Who's the guest speaker tonight? What's
No
the topic? No one. Right now, Karl Lentz is speaking, though.
So I'm going to see if I can find that real quick. Because like I said, before I did any of this stuff, it's just like...
yeah, that's good. We're going to wind up closing the call out. So we're on over 2 hours already. My goodness.
Yep, sorry about that. There is a P in it. It is. You are right. It is a Assumpsit.
Right? How do you spell it?
It's N-O-N. Here, I'll put it right on your website thing.
On the chat?
Yeah, what I'm going to do is I'm going to just put Black's Law Dictionary's fifth version of what it means.
Not legal typed it in there. ASSUMPSIT.
Yeah, there you go.
I had an extra T in there. Okay.
Yeah, so,
And the definition, is somebody going to put it in?
Yeah, did it pop the naked?
No, I don't see it yet.
It just means the general issue of an action of Assumpsit. It says, being a plea by which the defendant avers that he did not knowingly undertake or promise anything as alleged. So there you go.
Put that in the chat?
Yeah, I'm gonna try to cut copy and paste.
Okay.
There you go.
Object you put.
Yeah.
Assumpsit. A promise or engagement by which one person assumes or undertakes to do some act or pay something to another. It's non-contract, non-assumpsit.
Yeah, so see, that's what NA means, but everybody believes it meant not applicable, which I don't know why.
That's interesting. I didn't know that. See, I just learned something.
Yeah, like I said, I try to do extremely simple things, nothing complicated. You know, and that's what some of you guys who speak, the other man is nice, that Hailstone guy. He's incredibly intelligent when it comes to all kinds of statutes and codes and rulings and citations. But I'm like, you know what? You're overburdening yourself, guys, with this nonsense, their stuff. You know, you make your belief known, and then you might want to use their stuff to compare it with. But honestly, you don't have to use any of their nonsense. Not if you know that you're making a claim. So, you know, if you want to stop using I just put it in there, and I got that out of Black's 6th, and Black's 5th, sorry about that. And, see, in the UCC, that one man just said, non-assumpsit under the UCC is UCC 3-104.3. I'll put that in there, too, if the man wants to actually see where non-assumpsit means in the UCC. So, like I said, it's like, not only is that my belief, that I'm not contracting, but it also, you can refer to UCC section 3-104.3, which non-assumption means that I am not obligated and I did not promise to do anything that this man on the other side of this table is alleging that I owe him or a debt or something, so I have a duty to do. So that's the whole trick. If you can use their stuff, that's fine. But always use your beliefs first and then compare your beliefs with their stuff. And like I said, the dean was on the show after me. I think his show was like 191. And about 40 minutes into it, I started talking to him about that. And like I said, I could visualize the man saying, I see it. I see exactly where you're going with this. He said, okay. I said, I see how I can use that. I said, of course you can. You got to stop using it. Because their stuff changes all the freaking time. So if I wrote UCC 104-.3 on my IRS thing, what happened if next year 104.3 means something else? You know, like, well, what does 104.3 mean? It's like, I don't know, just write NA. Let's just say non-assumption. Let's just say NA. That means I don't, instead of writing out, I do not contract, da-da-da-da-da. I mean, you could do that with a traffic ticket, too. You could write NA on it if you wanted to. If you wanted to, you could go back to motor vehicles and say, oh, I lost my driver's license. Can I please have another driver's license? And they go, oh, okay. You know, want to take another picture? Here, sign a card. Sign it NA.
Well, that's my plan.
So then when you sign the ticket, the cop says, that's your signature? Because my signature, my driver's license is just KLZ. It's just some squiggly looking print symbol. It just looks like nonsense. So when the cop looks at my signature on my driver's license, he said, oh, that really is your signature. Yeah, it is. So just make it NA. So then it's non-applicable. It's non-assumptive. So you're just saying that, you know, well, I didn't contract with people. Oh, is that what you thought I signed? Oh, I signed it under threat of coercion or stress, because if I didn't have one of these in my pocket, Dean explained that one time. He said he got that a cop to admit that on the witness stand. He said, if I didn't have a driver's license in my pocket at that time, wouldn't you pull me out of my truck or taser me or hold me off to jail? He said, absolutely. So then he said the judge rolled his eyes because the judge realized that the cop just said, under threat, duress, and extortion.
Yeah.
Coercion. Right, that his body would have been dragged because he refused to beg for a permit, that he refused to beg for a license. That he knew that he would be in violation of code, and by violation of a code, not breaking the law of Canada, but in violation of a code, that his body would be hauled off to jail and his truck would be impounded. So he had to do it because he was threatened to do it. So everybody should just go around, instead of doing this Fremantle, Montana stuff, just sign everything NA. Go get your traffic driver's license NA, and then every time you sign from now on, it'll be NA. Everything you file with the government documents, NA.
Have you done this already?
What's that?
Have you done this already?
No, I thought about that a while back, to make your signature. That just thought it's hysterical.
Yeah.
I don't have a commercial license, so every time, it's funny, every time I get a driving ticket, and I haven't driven a tractor trailer since like 1990. So, well, it's great. Every time I get a traffic ticket in a personal vehicle, the cop is giving me a ticket under the wrong license. But he doesn't know the difference. Of course, when I said that,
what do you mean the wrong license?
I got a commercial license. It's like having an airplane license, and he's giving me been using an airplane license. It's like, this commercial license is federal. It's federally regulated. Oh, you're giving me a ticket because I violated a state code. Oh, well, this is a federal license. Sorry about that. Oh, did you write it under the wrong license? Oh, I'm sorry about that. Because, like I said, in my insurance policy lady, she said, oh, you know, write down all the tickets that you've got. So I wrote all the tickets. She said, wow, your insurance is going to be like $2,000 a year. I said, no, it's not. She was like, why? I said, because I'm operating under a commercial license. She's like, what? She said, well, you know what? I'll talk to the head office tomorrow, and I'm sure you're going to have to give me a big chunk of change before I can write you a policy. I came back the next day. She said, you're absolutely right. She said, while you're operating under a commercial license, she said, we can't use your private tickets against you on your private conveyance. She said, you're absolutely right. I said, of course I'm absolutely right. I said, why do you think I keep a commercial license? Because when my private conveyance can't be used against my commercial license, it can't be used against it to assess any kind of points on my insurance. Same thing when I'm driving a truck. When I'm driving a commercial truck, you can't use that to assess my points on my private vehicle at home. She's like, I see what you're doing. I said, yeah. and using a commercial license, but I have no intent on ever driving another commercial vehicle ever. He said, you're funny. This was back in the 90s. So, yeah, like if you ever want me to jump in, just give me a holler, and I listen to the shows on Thursday, but I usually don't jump in until the end of the show. I let everybody say their piece, and tell everybody to just hit me with questions like crazy, man, at the end.
I let you jump in as soon as you put your hand up.
Oh, okay, yeah, because I said Hailstone's a real good guy. I talked to him on a couple other shows. He's quick, he's good. And
I love Hailstone.
Yeah, oh yeah. But like I said, like you said to him last week, you said, when I can understand you, Hailstone, and keep up with you, she said, you said some lot of good stuff. You said, but you lose me so many times. It's like, that's right. Because if you try to rely too much on somebody else's beliefs and somebody else's codes and statutes and rulings, you're going to get all messed up. So you just try to keep it extremely simple and just say, look, I'm a man, I have rights, you're the government, you have a privilege, exist. Until then, you leave me alone. If no man has come forward to make a claim against me, there's no reason for me to be in court. So is there going to be a man present in court to make a claim against me? Yes and no. And that's the only answer to in this country, because like I said, we live in a common law land still. If we lived in France, every single thing I said is total nonsense. There's not one thing of any advice I'm giving to anybody. If we lived in a civil code land like France or Italy or Germany, none of this would work. None of the stuff I'm saying would mean anything. It only works here in common law countries. And that's the whole trick.
That was in court on, it was called Docket Day, and I asked him, is this a court of record? And I got that from you, or is it a court of judicial court, or a private court, and he said it was a court of record, so same deal?
So what's great is when you say a court of record, like I did to the Marshall folks. And so when you do the court of record, you just say, well, under Blackstone's, not Blackstone's, you don't have to go back that far. Go in 2000 Black's Law Dictionary. Say, oh, this is a court of record? Great. Because a court of record only operates under the common law. Thank you, Judge. He says, no, it doesn't. I said, there you go. Black 6, 2000. Read it. What does it say? The court of record operates only under the common law. So this is a common law hearing or trial. Which one are we having? Because hearings are administrative. Trials are common law. So is this a hearing? Yeah, well, this must be administrative. This must not be under the common law. So we're on the wrong side of the court, Your Honor. We're going to have to move it over to the correct side of the court. We're going to have to move it over to the common law side because you said this was a court of record. A phrase, a court of record, not three independent words. See, because a court of record can be three separate standalone words. Or court of record is a phrase. It's a term. It's a term of art. So is this a court of record? One word. Just like a private attorney general. Now, you could be private attorney general. It could be three separate words. Or you're a private attorney general. It's an actual title, like a definition of something. You can't separate the three words. It wouldn't make any sense. So, that's the whole trick. You get them to say it's a court of record. Lovely. You throw them that piece of paper that says Black's Law 6, 5th. It's all his versions of Black's. It says court of record operates only under the common law. That's the very first thing. Because everybody knows, it's like independent of the magistrate, independent of the other things everybody knows. It has the power to contempt the whole court or fine, So court of record, you say, lovely. Because that's what they did to the U.S. Marshals, too. When I went to talk to them, I said, I went upstairs and I asked the clerk of the court, I said, is this a court of record? She said, absolutely. So he said, yeah, well, there you are, the court's of record. I said, good. What's a court of record? And I showed him the book. He said, operates on only under common law. There you go. So it's only common law that they can conduct upstairs. So when they try to bring me forward under Title 42, they're moving me into some sort of administrative court. They're moving me into some sort of code court. So they're moving in error. So I have to drag them back and say, no, I don't move any complaint under Title 42. I make claims as a man, and you did me wrong.
And do they make you stand up when the judge enters the courtroom? Is that common law also?
That is one damn good thing that I'm glad somebody brought up filing. When you walk into court, you stand up from the minute you walk into court till the minute you leave. Because what you're doing is you're standing in common law. And when you say, what are you doing? I said, I'm standing. It said, this is a court of record, right? This is operating under common law, right? Yeah. To me, you're standing in common law. Never give up your standing. So even though it's a little theatrical, and even though it's a little funny, I never sit down. From the minute I walk in the court, I said, I'm just here to answer all claims against me. Who's going to come forth and make a claim against me? And this is what I tell people, too. What's funny is, if you're really, truly holding your court and you're making a claim, what you do is that you say, I was here being summoned to appear here at 9 o'clock. So you make your claim at 9 o'clock. Is there any man who's going to come forward and make a claim against me? Because at this point, I have still not had a claim been presented to me. So I say to people, I said, why don't you guys just walk in the court, and at 9 o'clock, just say that 3 times. Is any man here to make a claim against me? I'm here to answer all claims. Is anybody here to make a claim against me? And as they say, well, just wait, the judge will be here soon. No. I still have a claim. I still don't have a claim against me. So then when you say 3 times, and then you leave. You say, I was there, Judge. You told me to be there at 9 o'clock. I was there at 9 o'clock. It doesn't say to be there at 9:01. It doesn't say to be at 9:02, right? Because if I was here at 9:01, I'd be in trouble, wouldn't I, Judge? Yeah, you would be if you were late. That's right. I was here exactly at 9 o'clock. I stood up and said, is anybody here to make a claim against me? Nobody answered.
Does the court send you anything in where you're at? Because they don't send anything to us here.
Well, what are you talking about? When you get the traffic ticket, they just tell you to appear 30 days?
Yeah.
Yeah, they just tell you to appear in 30 days. So like I said, what you have to do is you can't wait. Everything, like I tell people a million times, you never open your mouth in court. Everything has to be in writing. So you already sent this to the other side. So is there any man who's going to come and ever make a claim against me? I'm waiting for a claim. All I've gotten was this silly citation about some sort of code violation. I have no idea what Section 6011132 means. I don't have a clue, and there's nothing in the law that forces me to interpret your code. There's nothing in the law says I have to know what your silly numbers mean. All I know is I was traveling from point A to point B. As far as I know, I didn't cause any harm to any of God's creatures, great or small. I didn't cause any damage to any man's property. And I didn't have a contract with that man who pulled me over saying that I was driving his car in a manner that we did not agree on. That's my car. I can drive it any damn way I want. So who's going to make the claim against me? So like I said, the prosecutor usually reads that stuff when I file. I give it to them, and they read it in 2 seconds, and they just laugh. They go, you some sort of a lawyer? I go, no, I'm your worst nightmare. That I can guarantee. He says, well, we'll see. Like I said, I said that to me. He said, I'll see you in court in 30 days. I said, well, then I'm going to get you for barratry, filing a malicious claim against me, and filing a false claim against me. I said, believe me, you're going to get a claim handed to you from me, and then you're going to have to answer to my claim. So they were like, oh, yeah, funny. It's like, okay, good. I'll see you guys in 30 days. And like I said, the whole trick is you walk in there, it's up to say, we hear that I broke the law. Is somebody making a claim that I broke the law? Because the law...
You said you got some of his claims on your site?
Yeah, let me say it for the recording. It's myprivateaudio.com. myprivateaudio.com. Started out as My Private Audio, but turns out everybody else gets to use it. It's the easiest way. All the documents from all the guest speakers that they send me anyway are posted there on, you go to the guest speakers page and click on Karl's name, Karl Lentz, and it'll take you to his documents and what he sent me. It's all posted there. And also other information. Also, if you look at the call history page, it also has pertinent information for the calls we do. And I include other calls sometimes. There's a good guest speaker on. And I guess that's it. We're going to wrap it up for tonight because we're in 2 hours, 43 minutes.
Sure.
And my son is hungry.
Oh, hey.
All right. Thanks so much, Karl. Thanks, Jesse. Thanks, everyone that came on the call. I appreciate your contribution. It's always fun. I like it better when I don't have a guest speaker. But, you know, there's a time for this and there's a time for that, right? All right, everybody. I love you. Take care of each other. We'll see you next time.
Okay. Thanks, Angela.
Thank you.
Thanks,
Good
Karl.
night. Good night, Karl. Thank you.